An additional change that we need to make for our Industrial Insurance Act is that we need to vest the Board of Industrial Insurance Appeals with continuing jurisdiction to prevent manifest injustice. Now, what does this mean? It means that if something is truly messed up and it was previously found and under our current system would be final and binding, but everybody that looks at it, whether they're on the defense, whether they're representing the injured worker, whether they're the judge, everybody looks at it and they say, wow, that's a rough circumstance that never should have happened, and it is so bad that there is a manifest injustice. Well, if you can identify such a circumstance and you know that the law has been applied in a way that is that rude and crude to the injured worker, then there's no reason why we shouldn't allow our courts to change it. Now, in New York, as one of the examples of sister states that are very progressive and yet very controlled in their expenditures and everything else, there does exist this continuing jurisdiction for the purpose of preventing manifest injustice. And here's an example. An injured worker will have been cheated on their wage rate, but maybe they're illiterate, maybe they didn't know what was going on, maybe they were really sick or injured at the time that their wage rate was being determined, maybe there's some exigent circumstances so that they can say, look, so much was going on, I just didn't catch this thing. Well, they get slammed with a wage rate that literally reduces them to the level of poverty, and then they continue because their injuries are so bad, they continue to live that way for a period of years before they finally get an attorney. And the attorney looks back in their case and says, wow, no way this electrician, no way this plumber, no way this iron worker should have had a wage rate that looks like they were earning less than minimum wage. Minimum wage is the public policy of this state. No way that wage should have been set that low. Well, in our current system, the Department of Labor and Industries, the board, everyone else just says, well, it's too bad, so sad, because it's final and binding. But yet we can look at that situation and go, wait a minute, this person is now paralyzed. They're never going to be able to earn again. Clearly, there is a manifest injustice if we don't do what was right. So the injured worker comes to court and tells the judge, here's what was happening, here's why it's a manifest injustice. The judge then turns to the employer's attorney and says, well, why is this not a manifest injustice? And the employer's attorney says, well, because they didn't speak up fast enough. And the judge says, well, looking at all of these things, it looks to me like self-insured employer with massive revenues. It looks to me like you really just took out a long-term loan on the back of an injured worker, and it's time to pay back the loan. So I'm going to, based on the facts that you're stipulating that the wage was incorrect and the injured worker is also able to stipulate to that, based on this stipulation and that it would be contrary to public policy to leave this poor person wallowing in poverty when that's not what the Industrial Insurance Act intended, based on that, I'm just going to change it, and here's your new wage order. And then back money is paid to the injured worker, and the injured worker going forward gets the fair wage rate that was always intended by our legislature. We need to adopt this notion. It's adopted in sister states. It needs to be adopted here in Washington. The legislature must act to vest the Board of Industrial Insurance Appeals with continuing jurisdiction to prevent manifest injustice.